Jelani for the people.
Assistant Public Defender Melissa. Mr. Mack, and sir, can you unmute and state your name for the record, please?
Giorgio Mack.
And Your Honor, we have received some information. It sounds like the complaining witness has been able to recover the phone in question, that she found the phone, so it wasn't taken. We are asking if the court would consider dismissing the case today. In the alternative, we would like to set it for final settlement.
I'd request final settlement, Your Honor.
Okay, so if the phone's been found, why am I setting it for a final settlement? I guess I'm trying to figure that out.
May we approach?
Yes. Can you put myself, Miss Kleeman, and Miss Lundy into a breakout? All right. Record should reflect we've had a bench conference. Set final settlement conference in this matter, SMAC, for May 4th. 2000.
Is it possible that I can say something?
I wouldn't right now, sir. I'm going to give you a call once I'm done with court and we'll talk about it more, okay?
No, I prefer that I say something, man, because I don't understand what's really going on.
Okay, what do you not understand that's going on, Mr. Mayor?
I'm trying to understand how I heard what was said in the first part, and then how I wasn't able to hear why is being pursued further.
Well, I'll answer it this way. I had the initial question, wanted to talk with counsel about it, which is why we went into the breakout room. And they gave me a satisfactory answer, or certainly the people did, as to why this matter should continue. It's not something I can resolve between the different parties' positions. Ms. Kleeman indicated and shared what you had indicated, or a certain statement you had made, and it's not something that can't be resolved. So I understand now why they want it set for the final settlement conference date.
Your Honor, this affecting my whole life and everything. I don't even understand how I was arrested. So how I even so this is my whole thing. So it's altering me with community corrections and everything. Is altering me with employment. And today I'm just hearing a couple words that just say, all right, give us another day. I didn't hear anything that was as a citizen. I believe I didn't hear anything that would substantiate my life being altered, the presuming of innocence and anything of that nature.
Sir, hold on. You're presumed to be innocent, which is why when what was said, I asked the question of why. That's why. So then they wanted to explain to me why. They've given me a satisfactory explanation because there are two different versions of this at this point.
Exactly. So
if there are two different versions, then the matter has to proceed. I don't have a choice, but it has to proceed. Now, as to the arrest or anything like that, by design, I don't know anything about the particulars of that, nor why the police officers did what they did at that point. I don't know.
But with all due respect, wouldn't that information be in front of you? Like, just to see.
Okay, so as a citizen, maybe one thing you need to understand is how this system works. By design, I am not to know everything about the case. Your attorney is the one that knows about the case. The prosecutor knows about the case. ultimately the case will come before me. But when I see certain things that might affect the procedural nature, then that's why I asked the question that I asked. Because somebody had to give me an answer. Partially because of what you said, but for other reasons also. And so they gave me their reasons. It still amounts to where there is a conflict in the stories. So the matter has to proceed. Okay.
Okay. Okay.
Sometimes I tend to tell people, I don't want you here any more than you want to be here. So, sometimes it happens that way too, okay? So I'll set final settlement conference for that May 4th date at 1:30. Jury selection if necessary at 8:30. And what I was going to say before I was addressing the defendant, if the parties would seek to expedite it and waive, then you should strongly consider that because I can get you a date before that. You do.
Yes, Your Honor. That's something that I'll have discussed with Ms. Kirby, who will ensure will discuss with Ms. Clayman.
Okay, very good. So I'm setting these dates, sir, so that you understand what that meant. I'm setting those dates. If potentially there could be a waiver, I could probably set it for resolution at an earlier date, but that's when I had my jury. Okay. All right. Anything else? Any other questions you have, sir?
No, sir. Thank you.
All right, thank you. Fine, we'll continue.
We have no objection. We would just join in with the request to give him a little more time to pay the 192.
Mr. Dunson,
Yes.
You want
the
to?
judge wants to hear from you.
Oh, I was just waiting till y'all was done speaking, but I had to get caught up on some bills, and I'll be able to pay it once I get my next paycheck on the 25th.
So you paid somebody else before paying me?
I wasn't
No,
gonna have no DTE.
Hold on. I don't need a long explanation.
Yeah, I had to get my life
Cleveland,
cut off.
Doesn't that seem like a yes or no? I'm just trying to figure it out. Is that what happened, Mr. Dunson?
Yeah.
Yeah, you paid somebody else before paying me?
Yeah, I couldn't sit in the dark. I was gonna charge my phone to be in court.
Hold up a second. Hold up a minute. So those people at DTA, can they throw them in jail? I don't know. Somehow I think he might be making a bad decision.
The judge can get you lights, Mr. Dunson.
Yeah, I can get you lights, put a roof over your head. They got food there too.
I don't want them lights.
Oh, okay. All right. See, now he's getting particular. All right, Mr. Dunson, how much more time did you need, sir?
I can pay it on March 25th.
All the way out there. See, that's what I'm talking about. If he had called DTE, he could have paid them on the 25th.
No, I could.
You'd have paid the 192 arrearage on or before March 25th, 2022. Is that
Yep.
the day you get paid?
I get paid before then, but I just said then just in case.
Hold up. Hold it. Now he's gonna sneak around. Get paid how much before then?
A few days before then.
A few days.
Yeah.
Not like the day before.
No, I cut like 2 days before. I get paid on the 23rd.
See, you know what? Yeah, he gonna get in trouble with me. If he had just said I get paid on the 23rd, we wouldn't have had a problem. I'll make it the 25th. I was gonna give him actually an extra 2 days to the 28th if he got paid on the 25th, but now that I know he had the money by then. I wanted March 25th. No excuses.
Yep.
Continue all all terms as previously ordered. Your next review hearing will be set for June 13th, 2022, 1 p.m.
Yep.
Thank you.
Thank you.
Court does recall the case, People versus Jamil Forbes.
Ashley Lundy for the people.
All right. My understanding is that there will be an order forthcoming allowing the withdrawal of the public defender's office, and that the Office of Managed Assigned Counsel is appointing Mr. Drukas to represent this defendant.
That's my understanding as well, Your Honor.
Edward Drukas on behalf of this defendant.
This is set for arraignment. Mr. Drukas, just kind of bring you up to speed on this. He has one count of domestic violence and an account of assault and battery as against the same person.
Okay, we will
Excuse me, Your Honor.
Miss Robertson, it's not our turn yet.
Okay.
Thank you.
For purposes of the arraignment,
Go ahead.
stand mute and waive reading. And we'd ask that a PR bond be set.
Defendant ever waive formal reading. Standing mute, court will enter a not guilty plea. Pretrial April 4th, 2022, 1 p.m. All right, as to bond.
Your
Refer
Honor,
to-
Miss Robertson is present. She wishes to address the court based on bond. She's the named victim in the case. She wishes to have contact with the defendant during the pendency of the case.
To whom we
Hi,
speak
Your
with.
Honor. Can you
Hello.
see me?
Yes, I can. All right, what do you want to say regarding bond, ma'am?
Okay, yeah. So, personally, I didn't want to press any charges, and I was asking if the restriction for us to have no contact be lifted. Me and him were recently just looking to move into an apartment together, and we were supposed to sign a lease, but because of the no contact, we weren't able to, and we didn't want to move forward with that until everything was settled. And then, to my understanding, when I also called, those two charges were for the same situation. So I thought it was only supposed to be. I was told there was only one charge.
Oh, ma'am, I don't, the last question, the last thing that you posed, I don't know. That may be certainly out of your bailiwick, and I was just apprising Mr. Forbes' counsel what charges were in front of me. Anything from the people in terms of
I have the same concerns I have in many domestic violence cases regarding contact between the defendant and the victim. I will note that this is an older case. It took some time to come to court. I believe the incident happened at the end of last year. Leave it in the court's discretion.
Mr. Drukas, anything further?
I just like a potential order that would be a no non-consensual contact. In the event that there was an issue that were to come up, she'd have a way to tell him to leave the situation.
So, sir, I'm going to order that you report to community corrections for a review of your conditions of release and potential drug testing. You understand that, sir?
Can you repeat that?
You are ordered to report to community corrections for a review of your conditions of release and requirements regarding any drug testing. You understand that?
I understand it. Is there a reason why?
Because I'm ordering it. Any other reason you need? Mr. Drukas?
I guess not.
When somebody asks me that question, I always have an issue with whether or not they're going to follow my conditions. So I'm going to give you an opportunity right now because I don't think Mr. Forbes has been before me before and understands
I
exactly.
don't mind to go into a breakout room.
So
And
we'll put him into a breakout room with you. Back on the record in the case of People versus Forbes. Drukas, is there anything you want to tell the court?
Thank you, Your
Well, I
Honor,
think
for that
we-
brief breakout room. I did get his contact information. I did go over what the issues would be with regard to following your court orders. I think he understands that now. He's currently not testing, I don't know, is the court looking for drug testing and alcohol testing, or is it sort of a referral to community corrections?
The referral to community corrections for drug testing and a review of the release conditions, which I'm about to indicate.
Okay. I did go over that with him. I went over whether or not there would be potentially anything in his system. And I told him that there could be a potential issue with marijuana. And he may or may not have a medical marijuana card. I told him to get me a copy of that card. And if he doesn't provide a copy to the court or ask the court's permission through the use of that medical marijuana card, that he would not be able to partake in any sort of medical marijuana. So if he were to initially
If
test
he
it,
has the card, then what he would need to do is get a copy of that card when he goes to community corrections. Get that to them.
okay, and unless they have it, yeah, unless they have it, then he would not be able to partake.
Correct. Because I don't restrict and can't and won't restrict medical, but only restrict recreation.
So I went over that with him, and I told him that he'd need to report within, I believe the court was going to order within 24 hours.
That is correct.
And I told him that the issues that this is a bond condition, that he needs to follow that, and there can be repercussions if he doesn't. Is that a correct statement, Mr. Forbes?
Yes, sir.
I will change the no contact provision based upon the statements made by Ms. Robertson to no non-consensual contact with Ms. Robinson. Do you understand those terms, sir?
Yes, sir. So you said we can't have contact, correct?
Said no non-consensual contact, and what that means is that you can have contact as long as she consents to the contact. If she indicates that she doesn't want to have contact with you, must immediately leave.
Okay.
I've signed the order. He is to report to community corrections within the 24-hour period. Thank you.
Thank you very much, Your Honor. You can sign
Thank
off,
you, Your Honor.
Mr. Forbes. I'll give you a call.
All right.
Court calls the case, People versus Matthew Miska.
Ashley Lundy for the people.
Morning.
Mr. Mishka's case takes a wild turn. Multiple tether violations, a warrant in another county, and a possible OWI arrest. Every time he tries to explain himself, he digs a deeper hole. The judge has zero tolerance for games. This is what happens when you're caught in multiple violations. Bond gets revoked instantly.
Afternoon, Your Honor. Michael Gaddy, Assistant Public Defender, on behalf of Mr. Mishka, who I'm looking for on the feed. There he is. State your name, sir.
Where'd you see him? Is he on there? No.
Wearing a green shirt.
Yeah, he's wearing green. Probably the only one wearing green today, Judge.
Oh, there he is. Okay. He's
Hey,
on
how
my-
are you, Judge? Happy St. Patty's Day.
And to you, sir. All
Thank
right.
you.
I got him. All right. What are we doing on this case, folks?
Your Honor, in this matter, we've been talking about potential sobriety court. I have sent an email to the sobriety court team at 15th District Court today and hoping to find out if he's eligible. I'd ask the court to adjourn this matter maybe 2 weeks so that I can get that done. I will endeavor to get it done as soon as possible and get Mr. Mishka through their screening process. I have had a chance to speak with Ms. Landy, and she has informed me that there is a warrant for Mr. Mishka out of Livingston County that I've addressed with him.
Your Honor, my notes indicate, looks like the last time that we were here on the 24th, we had a warrant at that time. So I'm not sure how he's out of custody. But can the court confirm that he is testing? Because that was an issue before our last hearing.
I had court mic last time. That was why. Remember?
I wasn't your attorney last time.
Well, on the 24th, I had court that day in Livingston County, and I had talked to, I forgot who with your office over there, Your Honor, and they set up today's court date due to that missing that court date because Livingston scheduled the same time as you or your court date.
Your Honor,
The
it's my
last time on
understanding.
February 24th, I issued a bench warrant for his failure to appear, issued it immediately. Typically with that, there was then no court date set. The defendant then came in and requested that be reset. So we reset his case, his bond, with all of the conditions reinstated. And then, so we recalled the warrant and then we set this date.
And Your Honor, in that case, the last time he was before Your Honor, I believe was February the 3rd. And since February the 3rd, there have been 3 obstruction events confirmed by house arrest services, as well as TACs, alcohol being detected through the.
Hold on. Since February 3rd,
Yes, Your Honor. February 9th, February 10th, February 12th. Do you have the?
I do. I see what they did.
Can I say something, Your Honor, Mike? I've been on this tether for a while, Mike, and I've been doing 6.
Sir, let me do the talking, okay?
Yeah, no, all right, no problem. I just saying I've been tested 6 times a month for Livingston County, ETGs, full scale. I have not been drinking. I got the tether on and everything.
I'm just pulling up the bond violation right now, Your Honor, if you'll give me a sec.
I got February 9th at 6:19. February 10th at 8:14 PM. They're all PM. And then at 10 PM on the 12th.
These are February?
Yes, sir.
No, I know I haven't been drinking. I've never felt so good in my life, Your Honor. I mean, I have the tether. I got Livingston County. I'm doing everything.
I'm not going to be able to stop you from talking.
I know, Mike. I'm sorry. I'm just nervous. I'll shut up.
Your Honor, it's also my understanding there's a note now I see in the file from Mr. Danner that Dorian Harrow, the probation officer for defendant, that the defendant is in violation status in Livingston County, was arrested on March 3rd, 2022 in Oakland County on an OWI, and they're awaiting blood results.
I wasn't?
You're saying he was arrested when?
Pulling up the correspondence that Mr. Danner received from the probation officer, and I'm happy to forward this to the court if we want to pass it. But it's my understanding he was arrested March 3rd.
I was not.
Well, sir, here's the thing.
Yes, Your Honor, I'm listening. Sorry.
Just so that you understand.
Yes, sir.
Your attorney has told you to be quiet. I joined with your attorney that you should be quiet.
Yes, sir.
Not say anything. You're continuing to say something. There's now evidence being presented to me that there may be other incidents. I'm going to suggest very strongly that you be quiet.
I will.
I'm also going to indicate so that you're clear as to exactly how I work.
Yes, sir.
I hear everything anybody is saying. So if you're telling me that it's not the case, but I determine even on a preliminary basis that I believe it to be the case, I will make you the guest of the Washtenaw County Jail. So it's going to behoove you at this point to be quiet.
I'm throwing away. I'm done. Sorry, sir.
Court will pass this matter.
Thank you, Your Honor.
Sorry, Mike. All this was new to me. So
just mute your.
And again, you should be quiet.
Oh, I'm sorry. I thought I was out.
Yeah, I know. Court does call the case, recalls the case of People versus Miska.
Ashley Lundy for the people.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Mishka, Your Honor. Mr. Mishka is on Zoom. He's Mr. Mishka, just mute yourself and state your name only.
He's there.
Yes, I see him. He's outside.
Matthew Luke Mishka. Can you hear me now? Matthew Luke Mishka.
Your Honor, I forwarded the court the correspondence we received from the defendant's probation officer regarding the Oakland County arrest. I also printed out what I was able to get from VineLink, which shows the record of his arrest on March the 3rd in Oakland County and a release on March the 4th. It also has a color mugshot. We're showing a individual, I believe, that bears a resemblance to the defendant with the same name. So I do believe he was arrested in Oakland County on March the 3rd, like I stated, and I did communicate with Mr. Gaddy, who also confirmed his warrant in Livingston County. So at this time, he's got tampering with his scram tether, a warrant in Livingston County, and was arrested in Oakland County on March 3rd. So I'm requesting that his bond be revoked and he be remanded to the custody of the Washtenaw County Jail. Thank you.
Your Honor, if I could, it's my understanding that he does have a matter in Livingston County. And in terms of the tether violations alleged here, they're for blockages except for the 2 in February. But Mr. Mishka has been testing at DNA at a place called DNA Services in Howell 6 times a month, doing full panels as well as ETGs. So I would think that if we could obtain those results, it would be would clear up that in terms of any usage tether. In terms of the March 3rd event, it's my understanding that Mr. Mishka was not arrested, and that it was a person named Veda Oro. I have not been able to confirm this one way or the other, but that's I've just found that out. I've just found out about the Livingston County issue this morning. I'd ask the court to set this over. I'd also ask the court to set this violation over as well. See if we can't get those results and share them so that we can determine. The real issue here is usage, and so if we can determine what's been going on, it's my understanding he has been on the testing in Livingston County, which is a non-alcohol related matter, I believe, but he's been on it since last July. Or August 1st. I can't remember if it's July 1st or August 1st, no, Judge. Of 21.
Here's my, I guess here's going to be my issue is I'm looking at the email from Mr. Harrow. Outside, and I'll set aside for the moment the arrest on 3rd. He's currently in violation of his status on probation in Livingston County. The other thing is that as I'm looking at the VineLink photo, if that's not him, then I would be absolutely shocked. I would also be shocked by virtue of the fact that when, although it's blanked out on here, this individual that was arrested would have to have the same date of birth as the defendant does according to our records. I would also find it interesting that they would then report after receiving fingerprints that this is this individual and not someone else, or that the fingerprints came back to somebody else. So I find all of that would have to be a remarkable set of circumstances to happen for this not to be the defendant. The other thing is that his probation agent is also speaking to him regarding it. So he's got violations up there. He's got potential violations here. There's also the potential for an arrest that occurred in another county. So that's what the court sees. Mr. Gaddy, your client, I believe, wants to speak.
Mr. Miska, just keep in mind anything you say can be used against you, and I don't know what you're going to say.
I was not arrested. I did not give blood, but I was taken to jail and held because of the warrant by Livingston County and released the next day. I just wanted to clarify that. Since
Okay,
it all
Mr. Miska, you're making this worse for yourself because the arrest is for an OW. Hold on. The arrest is for an OWI. As I told you prior to the break and passing your case, I remember everything that everybody says to me. Now, if you want me to go back and play it, you first of all indicated you weren't arrested.
Well, I wasn't driving.
Whoa. You indicated you weren't arrested. Now you're telling me you were arrested. Now you're giving me
charge.
Why you know what?
I'm sorry.
Right,
I don't want to say.
I am so done. I think
you're breaking up.
I think you're playing games, and you're not going to talk your way out of it. Not with me.
I don't want to try.
So here's where we're going to go.
Yes, sir.
I will adjourn this out. In fact, I'm only going to adjourn it out 1 week because of what I'm about to do. So I'm only going to adjourn it to March 24th.
Okay.
2022 at 9 a.m. I am at this time, based upon what the court sees before it, I'm revoking the defendant's bond in this case. Defendant is ordered to report to the Washington County Jail. Sir, you are ordered to report by 3 p.m. today. Your failure to report, and I want a direct report, Scotty, at 3 if he's not there. If you're not at the Washington County Jail at 3 p.m., and you can try me if you want. You can ask any other defendant that's appeared before me that's wanted to try me on this. If you're not there, I'm issuing a bench warrant for your arrest. You'll be held without bond.
Okay, I'll be there today. What do you? What am I reporting?
We will come and get you if you're not here at 3 p.m. at door R4. Okay. You better be down at that door.
Okay, and does that have to turn myself in, sir?
Yes, it is.
I wasn't trying to talk my way out of it, sir. It was a lot of stuff coming at me, sir. I'm doing the right things. I mean, I did have police contact. I just wanted to let you know.
Mr. Mishka, the judge has ruled, sir.
Like I got to pick up my kid for school today. Like, oh my God.
Thank you. Okay.
What a wild courtroom session. We saw frustration over continuing cases, defendants arguing with the judge, victims wanting contact in domestic cases, and one man whose multiple violations led to his bond being revoked on the spot. The judge made it clear, the court sees everything, and excuses only make things worse. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.